So in other words, it didn't have to be in writing, correct?
Yep. No.
Go ahead and start back over, DB. My bad, bro.
Now you good. The particular parenting plan, a court-ordered time-sharing schedule, or a time-sharing arrangement exercised by the agreement of the parties, such as where the child spends a significant amount of time, but less than 20% of the overnights, with one parent, thereby reducing the financial expenditures incurred by the other parent, or the refusal of a parent to become involved in the activities of the child.
So as long as you have over 20% of the overnights, they have to deviate from the guidelines. Because the 20% threshold is a significant what's the word? Help me, guys. Brett, was it God dang it. Well, Florida has a different law now, but it's a significant amount of the overnights or some shit like that. But at any rate, don't forget in Florida now you have 50-50. And they have to be able to show that why you would not be entitled to. And you're talking about strict scrutiny, you're talking about fitness tests and all the other stuff. But there you go. And I gotta tell people this: go read the entire that may. But you want to read the entire chapter, and this right here is actually becoming more in play than it used to be because there's probably more guys now making more than $50,000 a year, right, Tondrick? Just generally speaking.
Yes, I would agree.
So you're talking about the long form, the 12.902, which again, people, I'm not, I have nothing to do with it, but if you want to, get in contact with Tondrick, we want to create a link for him. And as MJ and I'm sure Brett would say, and anybody else, you want to have those numbers right, because they will. Because what you don't want to have is you don't want to be behind the 8-ball and find out about. You don't want to be behind the 8-ball and then have to go and catch up, right, Brett and Mike? You don't want to have to go catch up because that order at first is good until you do it.
Yeah.
Yeah, I would say, Greg, even you want to prevent them from making mistakes to begin with. So you should go in there knowing what the calculation should be and be able to point to all the statutes indicating why that's the case. Otherwise, just like in my case, I tried to get the guy to correct it 3 times and he failed all 3 times. So you got to know what it is going in. Otherwise, they're going to make mistakes. You have to assume they're just going to make mistakes. It's just unfortunate, but that's the way I would approach it. And then on top of that, I would, now that I know what I know, I think it's very valuable for people to know the case law going in, because like you just stated, once they issue that order, then it's up to you to fight the judge, and the judge, they don't like to be wrong. So it's an uphill battle. And then you're in my situation where, 4 years down the road, I'm still fighting these people.
Right. And don't forget, if you don't raise certain issues, you waive certain issues.
Well, yeah, I mean, that's what they assume, but I don't think that's constitutionally correct, but yeah, that's what they'll do.
Well, you can't waive clear error of law. I'm not saying you can waive a clear error of law, but when there's certain discretionary matters, you can't. No, clear error. And by the way, we started saying what you don't want to look for things that are called abuses of discretion. We want to call things clear error of law.